Hi, everybody. I'm going to start here because I'm reading some written stuff. I am not an off the top of my head speaker, so I have written all my words here. Then I'll join Joanna up here for a more extemporaneous and some Q&A. So I am honored to be here, and I'm just enjoying seeing this community that is here for rural journalism. In these challenging times, strong communities are essential. Storytelling is one of the best ways to build relationships and strengthen communities, so I'll start with my personal story. I've worked in public media for 20 years, and I've spent the bulk of that time building the legal team at Oregon Public Broadcasting's headquarters in Portland. I believe in the power of the free press to hold government accountable, and I carry the words of the First Amendment with me everywhere. They're actually on my phone case in case I need them. So long before I was a lawyer, though, I was a young person growing up in a small town in Northern California, the part that's almost Southern Oregon. Our local newspaper was the Trinity Journal, a weekly publication that has been around since the 1850s. One of my cousins was a reporter, and my mom worked as a part-time copy editor. The paper has been the primary local news source in the county, covering all the local happenings, births, deaths, community gatherings, homecoming games, weddings, small businesses parades, county fairs, local arts events. Each issue also includes a spicy collection of letters to the editor, many of them focusing on the local board of supervisors or other hyperlocal topics. You have to wait a week to see the extra spicy responses from other local folks. And in the meantime, the letter writers pass each other in the town's only grocery store. Everyone knows everyone else's business, and there's plenty of gossip, but the local newspaper's reporting helps to establish a shared set of facts and hold local officials accountable. So I grew up without cable TV, and because we were up in the mountains, we only received 2.5 broadcast signals at our house. The strongest signal was a local public TV station. I grew up on Sesame Street and Mr. Rogers' Neighborhood, so the recent cuts to federal funding of public media have felt very personal. The national debate about federal funding of public media focused on NPR and PBS, but the bulk of public media funding has always been by law directed to individual stations whose mission is serving the needs of local communities. These communities will bear the brunt of the loss of local funds, so dismantling the public media system further weakens civic infrastructure for rural Americans at a time when we most need to strengthen our community ties. The language and priorities of Portland and Salem often don't account for the realities in LeGrand and Coos Bay, and these gaps intensify if we don't have shared stories to connect us. Without the oversight of local journalism, local government becomes less transparent, which impacts the community's understanding of what a healthy and functioning government should look like. So at OPB, we're thinking a lot about community storytelling and government transparency. Transparency at the federal level is becoming increasingly challenging, but we still have plenty of opportunities to ensure our local governments are meeting the needs of the people they were elected or hired to serve. So like many of you, OPB's journalists rely on Oregon's public records law as a crucial tool to do investigative journalism that keeps your communities informed. There's lots of topics I could talk about today, but public records is where I'm going to spend my time. So the public's right to access public business is a fundamental right, and Oregon's public records law begins with the assumption that records held by the government are open to the public. The opening sentence in the Attorney General's Public Records and Meetings Manual says, Oregon's public records and meetings law establish a simple expectation that its government will be transparent to her people. Government records are available to the public, and governing entities of public bodies must deliberate and make decisions in the open. This is great, public records for everyone, unless an exemption applies. As you've likely learned, there are a lot of exemptions in the public records law, and public bodies frequently use those exemptions to withhold records. Under our public records law, there are 2 general kinds of exemptions. Absolute exemptions are those that are categorically exempt. So if a record is covered by that exemption, it's withheld. The basic idea is that for these records, the secrecy interest will always supersede the right to know. So for instance, the state of Oregon will never just hand over your personal tax returns to a curious journalist, and your local police department won't publicize the names of child abuse victims. These are good public policy decisions. But not all exemptions are absolute. Many are conditional, which means that even if the exemption applies, the public body has a choice of whether or not to release the records. Courts and the legislature have charged public bodies with interpreting these exemptions narrowly, requiring them to err on the side of disclosure. What makes these exemptions truly conditional is that even where the records fall squarely within the exemption's coverage, the public interest may still require disclosure. So the law requires public bodies and courts to assess whether the public interest in disclosure outweighs the secrecy interest in every case. Conditional exemptions include things like criminal investigation records and records related to litigation. That's usually where public bodies will say, I don't want to give you these records because of the investigative exemption. So the legislature in 2017 passed revisions to the law that were supposed to shore up the public disclosure rights. They cited open access principles and made clear they wanted more accessible and efficient processes for requesters. They added new requirements for governments to follow, including a requirement that the government list any exemption it believed to apply when it was replying to a public records request. So the point was that not only does the public need access to records, they need to know why records are being withheld, so that requesters can fight denials and make sure government bodies are following both the letter and the spirit of the law. As we know from experience, good intentions and solid laws don't always reflect the day-to-day reality. In our experience, public bodies may often approach the question backwards, deciding they would like to withhold records, then filling in a reason. They may apply exemptions broadly, and they don't always do these balancing tests before they deny records requests. Many public bodies are not aware that when a conditional exemption applies, they still have the option to release the records. Okay, to be fair, local government workers who respond to public records requests are often super under-resourced and struggling to juggle competing realities, competing priorities. To a degree, they're not doing this on purpose necessarily. They may move too fast, they may make mistakes, they may err on the side of like a blanket rule or withhold whole files. Particularly if the records are adjacent to lawyer work or criminal justice activities. They'll sometimes redact full pages of information instead of carefully using their redaction tool like a scalpel. They will charge high fees that can be cost prohibitive for small news outlets, or they'll delay disclosure until a story is no longer newsworthy. This is where it can be very useful to have a lawyer, especially if you're not super familiar with how the public records law is supposed to work. The Oregon AG's Public Records Manual is a useful tool that anyone can use to help them understand the law, but is also imperfect. OPB's lawyers have learned that both the AG and public records custodians sometimes rely on habitual practices that may not reflect the actual language and legislative intent of the public records statute. Sometimes these habits even violate existing case law. Again, without a lawyer, it can be hard to navigate all these legal nuances. Another unusual aspect of Oregon's public records law is that it's designed to give regular folks tools and procedures to fight denials of access. In many states, if a local public body denies or delays your records request, your only choice is appealing to the Attorney General or going to court. Litigation is intimidating and costly. But in Oregon, the legislature set up a review process to evaluate records denials by local public bodies with a local district attorney. So you can appeal your case to the district attorney in the county where your records request was denied. This is an informal process that costs only your time and your understanding of the public records law. This process is also a key aspect of the legislature's open access policy, expressly meant to be accessible to non-lawyers. In fact, many experienced journalists are really good at navigating the appeal process. I recently told Therese Bottomley, who just retired as the longtime editor of The Oregonian, that someone should give her an honorary law degree for the public records expertise she's gained over the years. She handled appeals like a pro and knows all the important nuances of the various public records case law. We've had some lively discussions with her about recent public records legislation. We don't always agree, and the public policy implications of taking one path versus another with certain public bodies. But Therese didn't always do her own legal work. The Oregonian could afford to hire outside counsel with public records expertise. Reporting staff would learn from outside counsel and then use their knowledge to inform their own public records work. So just as public bodies have developed records request review processes that may not always follow the letter of the law, we've seen that district attorney decisions don't always reflect the open access intent of the law either. While having a lawyer is not necessary to walk through this local public records appeal process, it certainly helps. I'm going to share some really wonky data, so I know I'm already being wonky with lawyer stuff, and I apologize, but this is super interesting. Our team recently analyzed win rates for public records appeals. Who does this? That were decided in Oregon's appellate courts, and then we compared them to win rates in public records appeals that were decided by the Multnomah County District Attorney Office. So we looked at how often requesters won in appellate courts versus how often requesters won when appealing to a DA. The Multnomah County DA's office handles the highest volume of public records referenced by records petitions in the state. They do so thoughtfully and carefully. They're really good at their work. And their work is often referenced by other district attorney offices across the state. The Multnomah County Public Records Appeals decisions serve as models for everyone else. It's not binding precedent, but it's informative for other DAs who don't see as many records appeals or just may not have that much experience with the public records law. So that's why we looked at their office's response for our informal survey. At the appellate court level, both public bodies and records requesters almost always are represented by experienced counsel. Our analysis showed that requesters challenging an exemption in Oregon's appellate courts have won at a rate around 73%. So if a case is strong enough to reach the appellate courts, there's a good chance the records requester will win. On the DA level, the results are quite different. In those cases, we saw that requesters have completely prevailed in more like 28% of their appeals. When we counted petitions where requesters' arguments were partially granted, that success rate rose to about 49%. When requesters were represented by a lawyer whose firm had some media experience, the likelihood of a partial victory increased from 49% to 65%. So requesters by themselves, 28 to 49% wins. Requesters with experienced lawyers up to 65% wins, and this is at the DA level. It's not a scientific study. We're lawyers, not statisticians. I'm sure people could quibble with our methodology, but we were able to see a pattern develop that was consistent with the work we do every day. When requesters appeal public records denials to local DAs, the public bodies are nearly always represented by city attorneys or other lawyers who are familiar with the public records rules, while requesters, like most journalists, usually represent themselves. Very rarely are requesters represented by lawyers who specialize in media law or public access law. Of the total petitions we reviewed, only 19% were from requesters who were lawyers or who were represented by lawyers. So this inequity of advocacy means that the best arguments for disclosure of records are likely never raised. Public body arguments that don't hold water may end up prevailing because the requester in a case lacks the legal training to make the right arguments. It is essentially an unequal fight that sets up a history of district attorney decisions that are unintentionally skewed in favor of public bodies. Then those decisions become a kind of precedent, and they set the stage for future decisions that will be also unintentionally skewed towards public bodies. For decades, public bodies have been broadly and automatically withholding criminal investigation records without even assessing whether individual records need to be withheld. This was based on their understanding of a lead appellate court decision, which is from the 1970s, that said that's what they should be doing, except the case doesn't actually say that. Officials have been reading the case wrong for decades, in part, we believe, because it's convenient and gave them a strong incentive not to look closer, but also the asymmetry in legal representation and resources meant that nobody on the requester side had yet managed to identify and fight for what was hidden in plain sight. So when Oregon's news industry was financially strong back in the day, news outlets could afford to hire lawyers with expertise in navigating this type of nuanced public records debate. Charlie Hinkle from Stoll Reeves, Dwayne Bosworth from Davis Wright Tremaine, both built huge national names for themselves as public records experts. They're both now retired. Oregon still has a few strong public records lawyers. Other lawyers dabble in public records law, but it isn't part of their core work. Either way, lawyers are expensive. And those of you who work for news outlets that are struggling to pay your staff are less likely to be able to afford experienced legal advice. It's pretty simple. In rural areas, there may be no lawyers doing this work, or there might not be any lawyers at all. News deserts are a thing. Legal deserts are also a thing. OPB has had the incredible privilege of being able to develop in-house legal expertise so that we're not always having to pay outside counsel. The only way we can afford this is through the generous financial support of our community, including several major donors who have played an instrumental role in the growth of both our journalism team and our legal team. We've also developed a First Amendment fund so that community members can direct their donations to support our legal activities. In addition to working with local DAs, we've worked with the Sunshine Committee, participated in legislative drafting committees, done educational lobbying work in Salem to protect the strength of the public records law. We often find that OPB, ONPA, and SPJ are the only entities showing up for public records legislative work. This is troubling as many other stakeholders, from individuals to researchers to business organizations to universities, have an important stake in the functioning of government transparency. We are very interested in building relationships with more of these stakeholders. As far as I know, OPB's legal team is the only in-house legal team at a media organization in the state. I hope I'm wrong about that, and if I am, please let me know. We've been looking for like-minded colleagues to join us in this work. There's a huge need for partnership and coalition building among media organizations regarding all kinds of legal work, and public records work is just one part of that. We've spent a lot of time mulling this over. How can we help create a statewide grassroots public records working group? How can we share our legal knowledge with others? Our community's generosity makes our jobs possible, and we want to make sure that we pay that forward. For many years, OPB has partnered with law schools in the state to host law students as legal externs. We pay 2 students each term to work with us and get academic credit. Each student gets at least 1 public records petition and to work on, and many of those students have actually gone on to work in an area of law where their public records experience at OPB has come back and been important for their career. Last year, when the city of Portland sued OPB and one of our reporters over a public records decision by the Multnomah County DA, we hired a former OPB legal extern as our outside litigation counsel. She knew how we thought, she knew a lot about public records law, and she also had been a former journalist. For the past few years, I've been telling my team that one of the law schools that we work with really should put on a clinic to connect law students with journalists who can't afford lawyers. John Bile is OPB's Deputy General Counsel. He's sitting out here. I think he just got back from fly fishing. And last December, he reached out to his contact at the Lewis and Clark Law School, suggesting that OPB and Lewis and Clark join forces. The law school jumped on the suggestion. We met for lunch in January and hatched a plan. By June, OPB and Lewis and Clark Law School officially announced our collaboration, which will launch this fall. The Oregon Public Records and Government Transparency Project will give law students real-world experience under supervising attorneys as they work with journalist clients and public agencies to ensure compliance with the public records law. OPB's lawyers have drafted curriculum for a law school class about public records. 2 lawyers from our team, John Bile and our legal fellow Nora Broker, will serve as adjunct professors. Guest speakers will include district attorneys, lawyers who represent public bodies, and other government transparency experts. Lewis and Clark will host the class, provide logistical support to the students, broker the relationship between the public records requesters and volunteer attorneys from local firms who will supervise the law students. So this is a 1-year experimental project that will accomplish multiple goals. We'll be training students and giving them practical skills. We'll be building a network of local attorneys who are ready to step in with experience and efficient arguments. The project will be providing free advice to journalists at a time when legal assistance in this specialized area is hard to come by. We're looking at this as a test and learn situation. We will test the structure and the strategies and make improvements as we go. If the project is successful, I'm hoping we'll look at ways to sustain it on a more long-term basis. Okay, I'll stop. Joanna is going to share more details about how the Transparency Project will work and how you can get involved. Oops, pardon me.
I'm turning on my mic, although
I'm
as
turning
a
mine
trial
off.
lawyer, I'm not sure I need it. In fact, I might move it down a little. So I'm Joe Perini-Abbott. I'm the director of the Advocacy Center at Lewis and Clark Law School and a trial lawyer by training. I've never worked as a journalist, but I would say there's sort of two things that I know I have in common with all of you in this room. One is, as trial lawyers, we're also storytellers, except we're telling our clients' stories. And the other thing is that we are, for the most part, really committed to the idea of transparency and government transparency. And so to weave those together with storytelling, I want to just talk a little bit about the donor who made my job possible, an individual named, or a couple named Andy Johnson Laird and Kay Kitagawa. Andy Johnson Laird was he was basically one of the founders of the idea of computer forensic science and computer forensic experts in the legal field. He founded a company in Portland and did very, very well for himself in that work. And then when he was thinking about his testamentary gifts, one thing he did was he came to the law school because he had worked with the law school in various capacities, and he said, "Y'all are really bad at training lawyers." They're not prepared to take depositions. They're not prepared to question an expert in trial. And for those of you, if you have kids or nieces or nephews or spouses who went to law school, you know that's true. We are historically very bad at training lawyers in law school. And he said, I'm going to give half my estate to Lewis and Clark Law School to endow a position to do hands-on training of lawyers. And that's where my position came from. The other half of Andy Johnson Laird and Kay Kitagawa's estate went to OPB because he cared deeply. I speak of Andy, but it's Andy and Kay together. Kay just passed away first. Andy and Kay cared deeply about making sure the important stories, the newsworthy stories, and the stories about our government were told. And so when John Bile came to the school in December and said, we want to start a program, a clinic or a practicum or some sort of program where law students can get real world training to help journalists make public records requests. I couldn't have thought of a better program that embodied exactly what Andy Johnson Laird and Kay Kitagawa hoped for with their donations. And the fact that I can partner with OPB on this project is just deeply meaningful for that reason. You know, as a trial lawyer, and when I say trial lawyer, most of my experience has been in criminal defense, but I work with a lot of plaintiffs' lawyers who also work with my program. And to that transparency front, you know, open courts are so important to making societal change. I genuinely believe in the power of the civil justice system to push change forward. Things like some of the older journalists in the room may know that Oregon basically is the state that broke the tobacco industry, right? We were the state where private records from Philip Morris made their way to our senators' offices and then were made public. We are the first large verdict that ever happened against Philip Morris in 1999. We were the $80 million verdict that sort of triggered that happening everywhere and really started to create fundamental change in the public opinion around tobacco. And we're seeing similar stuff happen around social media and other sort of, when we hide our court system in private arbitrations, we're losing a lot of power. And so I'm very supportive of open courts, of what you guys do in your reporting on the courts, and using the courts to drive social change forward in partnership with journalism, right? Because if no one had heard the stories of the Philip Morris case, then it wouldn't have been nearly as powerful of a thing that happened in our state here 25 years ago. So with that history, Lewis and Clark was and is thrilled to partner with OPB on this project. it's sort of, I would say it's threefold. One, Lewis and Clark has a very strong history of our graduates wanting to go into public interest work. We have very strong environmental and criminal justice reform clinics already, and we are consistently ranked in the top of law schools across the country for graduates who are going into jobs to serve the public interest. And so we saw this as another opportunity to grow and serve our public interest lawyers, because whether they're going to go represent media companies or whether they're going to do other reform work, public records, experience in getting public records is absolutely critical to those fields. Our environmental clinics teach how to get public records because it's part of their job, our criminal justice reform clinic. So it's a tool that we want to help our students leave with. Real world lawyering, there's no better training ground for lawyers than real world lawyering. And so the opportunity to give our students more experience in real world lawyering was sort of the second prong of why we were so excited to make this happen. And the third prong is that, at least as I understand it, there's a real need. So other than John, I don't know any of you in this room. I met Kenneth while I was sitting at the table. So I know Kenneth for an hour and a half now. But I don't know any of you, and my greatest hope, though, honestly, is that I hear from all of you in the next year, that my students with the volunteer attorneys can serve you in fighting for public records in your community to help tell those stories and hold our government accountable. So we are thrilled to be partnering in this project, both for our student training and to hopefully serve the community with you guys. So now, how does it work, right? I'm guessing that's sort of the bigger question you all have. Because hopefully you guys are all thinking, this sounds great, now how do I get access to you guys? So our OPB council partners will be teaching the class, but they will not be seeing or handling any of your requests. There is a wall up. So if you think you have a real scoop by submitting a request for representation, you do not have to worry. John and the OPB folks will not be seeing any potential client information. There will be an intake form, and the intake form is live, although our website about it is not yet live. We will be sharing with all of the attendees of the conference the intake form. I'll share it with our hosts and they can email it out. So you guys can submit intake requests as soon as next week. Students won't be in and being able to help until September though. So just, if you submit something next week, thank you, but we wouldn't respond till September. So there will be an intake process. Ideally, you would have already submitted a request that was denied, and we would ask you to upload the request in denial so that we can see what was requested and make an assessment about whether it's a good case for the students to work on and whether there's an appropriate petition to be filed on your behalf. Then you would be assigned to one of our 3 pro bono attorneys. So we have attorneys at Tonkin Torp, Snell Wilmer, and Angeline Calfo, all of whom have public records experience, either extensive experience in litigating public records case. Hannah Hoffman, who's our attorney at Angeline Calfo, actually was a journalist with the Statesman Journal before she went to law school and has fairly extensive public records history. So you would be assigned an attorney. That attorney is working with 2 students, and they would help you on the DA appeal petition level or the state AG petition. A couple caveats. We're not doing FOIA. We're not doing any federal requests. This is all Oregon public records and government transparency work. So when you submit the request, we're focused on that. If we have an opportunity to grow, if this, it's a try and learn. Whatever you call it?
Test and learn?
Test and learn, test and learn. If this first year is successful, there's going to be possibilities to grow this type of work. But as of right now, it's just at the petition level for Oregon public records, so state or local agency requests. And then the students would work with you closely under the supervision of the attorney, the pro bono attorney, completely free of charge unless there's like filing fees or things like that, but all attorney time would be completely free of charge to you as reporters in your media outlet in representing you for the petitions. And one of our adjuncts, her greatest fear is that we're not gonna have enough people requesting. So we really, at this point, we want to see what the demand is. We want you guys to be submitting those requests. We're happy to help. If we're flooded, if we have 300 requests, then yes, we would create a way that we're gonna prioritize those requests. But for now, it is open to any media outlets in Oregon who need the support in getting public records. And that's all I have prepared.
That's a bunch.
Are there questions, comments?
A curious situation here since the federal furloughs have gone into effect. For decades, I've been able to talk directly to our local district ranger. 1 full month ago, we're in a wildfire-affected area. A 2-story warehouse that included all their firefighting equipment, miles of hoses, all their jackets, pants, chainsaws, everything, fire engines and support vehicles burned 1 full month ago. Every day for a week, I requested basic information, square footage, where the fire, how they fought the fire, so forth. The ranger told me that he had to forward that request to the Willamette National Forest. Daily, I was requesting information from Willamette National Forest, the local fire chief, and the state fire marshal. I didn't get a response for a full week until the local fire chief responded. Today, I just got a response from the state fire marshal saying that they're still in process. Today, I got a response from the Willamette National Forest. I haven't read it yet. You know,
Yep.
is this spilling over into other areas, this fear of speaking out?
That's a really good question.
And you know, when the furloughs happened, I identified 14 employees. I contacted each one of those to see if they would give me a statement. Even without identifying them, they all refused.
Wow.
It's scary.
And my brain is going, okay, which part of that is state and which part of it is federal?
Okay, the state fire marshal is state.
So state,
Yeah.
federal, and so there
I
are,
got a hold of Jack Orchard, and he advised me to file a request, which I did.
right, and at some point, because there are deadlines, the statute sets up a timeline, right, for when they're supposed to reply to you. And if they don't reply to you, that can be considered a denial, right? So if you have if you had a reply that was still, 4 weeks they hadn't replied to you, you could consider that a denial, and this program would be able to help. But the overlap with the federal furlough, that's very interesting. Hello.
Well, hello. I'm Emily Odo-PB. I know this lady very well as a public records hero. From your view, what can journalists do on the front end of their public records requests to make sure that by the time they contact this new service, they're equipping, they've done everything, just a few things on the checklist of things that journalists can do without contacting a lawyer to put you in the best position to argue their case?
There are many things journalists can do. One of the things is develop a relationship with the public records folks at your local public bodies. They're humans just like you are. They want to be treated nicely. They're overworked and underpaid and all those things, right? And when you send in a request, be really specific about what you need. I mean, journalists like to request the world, and sometimes you need to request all of the things. But if they come back to you and say, well, that's going to be all these exemptions apply, you can always talk with them and say, well, hey, what can we do to narrow this down? What if I make it less records? What if I make it less in scope? Just try to narrow your request and have just a conversation with them. A lot of the time that can get you the records that you need. Emily, were you thinking about anything else?
No, I'm just curious from, it's a long list, but from your mind, when you get, say, a request for records that
Oh,
They have to start all over.
I'm going to call on Mr. Bile.
Okay.
So the first thing you can do is use the posted process that public body has. And the reason that's important is because that gives you another avenue by which that you can complain about. If you use their process, you can actually, and they don't respond appropriately in 5 and 10 days, 5 days for the acknowledgement, 10 days to let you know if they're still working on it. No one actually fills in for 10 days or 15 days, so it's very rare. But you can use the law to take that inability to meet timelines, and you can get fee waiver. You can actually get a penalty on what actually that received issued, $250 penalty, and you can get an order to have the records disclosed even if exemptions apply. So that's a really good one. When I see my reporters have done that, and I see that the public body is kind of messing around, I'm feeling pretty good about my odds of getting records, and at least pushing that as a good level.
Yes.
So the University of Oregon also has a law school, and I did not hear you mention that.
We have legal externs that we have had from University of Oregon Law School. We love our legal externs from U of O. We have not had a direct conversation with them yet about this, but I heard through the grapevine that someone might be interested in talking with us about how they can join in too.
I did reach out to you, but apparently I reached out to the wrong person. So it's not that we didn't try. We just apparently didn't have the right contact.
It also helps that we're like 2 miles apart. So I
Yeah,
think we
it
were
literally-
just the physically closest.
They are, Lewis and Clark Law School is literally at the top of the hill that we can look up from OPB and see where they are.
It's also no longer, so I never talked to
I think in an ideal world, all 3 law schools could participate
I agree.
in things like this. And this is just a test run to see how it works.
And we think this is a model that could be scalable. We think it could be get bigger. We're starting with 6 students in the fall and 6 in the spring. It could be more than 6, right? We'd need to have that many volunteer attorneys to supervise them. So we've got right now a ratio of 2 students to 1 attorney. And it's something that could be replicated at other law schools too. Yes.
So Freedom of Information Act is just one area that newspapers might need help with. How about other areas such as copyright, claims of copyright infringement? Is there any thought of being able to help us with that? We have a claim or potential claim for copyright infringement, and we don't have a lawyer.
Right, and right now this program is going to be limited in scope just to public records again because we're testing it. We're see how it goes. In my ideal world, there would be a clinic where there would be a full-time faculty member who could broaden a program and make it include all kinds of things for media law. But we're starting here because it's a light touch. It's a not very expensive touch, honestly. It's mostly just costing us our time and the law school's existing infrastructure. So we want to just see how this goes and see what the demand is and see how it works. And then someday I would like to have I would love to see something that it covers all those areas.
Yeah, and just to echo that, University of Illinois has a First Amendment clinic. And that would be the dream, right? For this to grow into a full-blown First Amendment clinic that represents media outlets. Those are expensive. So our hope is to, proof of concept and then spin it into something donors are really interested in supporting us for.
Yes.
Are you open to student journalists? Because students do FOIA requests, students do requests.
Yeah, I think absolutely. Currently our intake form, when you look at it, you'll see it asks what media outlet you're affiliated with. You don't have to be affiliated with a media outlet, but media outlets would obviously get our priority. But I think we would consider a university newspaper or student newspaper to be something that we would serve as well. Especially if you all don't email us requests and we're not overflowing with them yet.
Yeah, and if we were overflowing, we might say, well, does the university have lawyers on staff who would help?
Yeah.
And that's actually an interesting question. would university lawyers ever represent students like that? Or would they expect them to just,
It might be a problem because, well, Brent can answer this better than I can, but often the information requests are information from the university.
so there's a little bit of a conflict of interest.
Right? Brent, am I speaking out of turn?
No, that's right. I don't think they lift a finger for the student journalists anyway.
Yeah.
I don't think they see it as their responsibility.
Yeah, so at this moment, I would say absolutely have your student journalists fill out the form as well. And we would consider those media outlets.
Okay, all right. Oh,
I just want to add that if fees are an issue for anyone who's trying to get public records, FORJ has a public records account for people. We have some money there, and you can email, and we would help with fees.
that's a great resource.
Also, you could use the track, you could submit a challenge to a denial of a fee waiver or a challenge that the fee was improperly calculated or is unduly high. So that's a topic area that's right for submission as well.
This is unrelated, but it's a legal question.
We are not giving legal advice up here.
I might be simple, but I'm with a very small community newspaper, a solopreneur, new to it, adherent to it. The person who founded it did not form an LLC. Is it wise to form an LLC for your small newspaper, or is it not necessary? Is
there a
there any
business
additional-
clinic?
Well, so I'm gonna use this as an opportunity to say you should reach out to the Lewis and Clark Small Business Clinic, who could advise you on that and help with the paperwork if it is appropriate.
And that is also a free service. So
Yes.
you would be able to get advice. Like one of the things I think people who aren't lawyers don't realize is that lawyers specialize the same way doctors do, right?
Yeah.
So if you have a broken toe, you don't want to go to a ear, nose, and throat doctor, right? So that is why Joe is saying, I have some friends you could talk to.
Yeah, I know nothing about whether you should form an LLC, but the Small Business Legal Clinic at Lewis and Clark does help, and probably would be happy to talk with a media company about something like that.
Okay.
Does anybody else have a question? Because like my dream is that next year at this conference, we might have a panel where some of the law students and some of the media partners are presenting about how this worked in practice and the kind of records requests that they were able to help you all with, or the fee waivers that they were able to help you all with. So really think about this as a service to each one of your outlets, but also to the field, like government transparency and flourishing journalism. Those are prime issues right now. We just want to support that across the state.
Yes, John.
Can we ask a question of the group? So when we started this clinic, we had 3 real concerns. Could we get volunteer workers? We able to do that. Will students care? Apparently there's a wait list for both terms. So we've gone over the first 2 hurdles, and our 3rd hurdle is are the reporters going to use this service? And so I'm curious, if you could think back over the last year, if this clinic had been in service over the last year, how many of you would consider submitting a request?
Nice. Thank you.
That makes me really genuinely happy, and
Yeah.
I'm just really happy to see those hands up.
In these really difficult times, we really just want to help. You know, I think everybody just wants to do something that makes the world a little bit better in some way, and it's gratifying to know that this might be something that could help you folks.
Will you tell us again how to get a hold of you and where to find you?
Yeah, so I'm going to share the link that is the intake form.
Oh, you've already said
Yeah, with the conference organizers, and they will push that out in an email in the next day. Or I'm going to send it. I have to drive back to Portland. I'll probably share it tomorrow. It'll go out, and then you just fill out the form. It will be on the Lewis and Clark website as of next week, but our website person was taking vacation, so I don't have it up there yet.
And it will stay up there.
Yes,
And people who didn't come to the conference are just
can access it. Yes, you can share it. It is.
And if by
Yeah,
The spring students are gonna need cases just like the fall students.
exactly.
Don't we have something coming up in September?
A continuing legal education class, yeah, at OPB, we're offering we're holding a panel for lawyers to come learn about public records, and journalists are welcome to. So,
I'll share the registration link for that as well, so that can also get pushed out. Yeah, if we have enough people come, we get to hold it in that cool studio space, right? It's my dream. I got a tour of OPB because I'm partnering with them, and it felt like I was a kid at Disneyland.
It will be online as well.
Yeah.
It's free.
Any other questions?
thank you, everyone.
Thank you, everyone.